who are return listeners to probably one of the nicest events that we have now at TRU. This has become a real sort of sacred space where we come together and listen to some of the fabulous scholarship of our colleagues, and it gives us all a moment to step outside of what we do every day and really sort of relish in the ideas that we get to listen to. So before we get started this evening, I just wanted to obviously recognize and honor with great respect that we stand on the unceded traditional territories of the Kamloops to Secwepemc. This is our first house whose territory we sit on and hosts our lovely Kamloops campus. And also to our second house, Tahulk, who hosts our Williams Lake campus. We are located on their unceded ancestral lands, and from these lands we serve students and peoples from many nations. So the inaugural Professorial Lecture series that I'm so pleased to be a part of was really an initiative before my arrival here at TRU that was created by the Senate Research Committee in 2022, and was something I was very happy to support to make sure that we could host and properly celebrate our colleagues. So in fact, what we stand here to do is to recognize the individual scholarship, but also to recognize the accomplishment of promotion to the rank of full professor. It is an accomplishment that follows a long road. It is a rigorous process, sometimes an exhausting process, and sometimes one that is isolating. So we are here in community to recognize, again, the accomplishment of our colleague tonight, Dr. Chris Hunt. So the process of becoming a full professor is one in which your work is heavily scrutinized, not only by your colleagues, but also by the national and sometimes international communities. It is quite a high bar, and it is one that is met here in the recognition of some really phenomenal commitments to social justice, to equity, to sustainability, as we heard from our previous scholars talking about the importance of paying attention to our natural environments as well. So there's much here at TRU to celebrate. So we have with us tonight Dr. Chris Hunt, who I am going to turn the floor over to our Dean of Law, Daliane Millard, who's going to introduce Chris, and then we'll hear from Chris himself, and then we'll hear from a respondent from the Faculty of Law as well. So it'll be a great evening. So welcome again. Thank you for coming.
Good evening, everybody, and thank you so much, Dr. Balfour. Dr. Hunt is a professor at TRU Law, and he was an associate professor from 2016 to 2022. And an assistant professor before that, from 2012 to 2016. Prior to joining TRU Law, he earned his LLM and PhD from Cambridge University. He clerked for the Justices of the Supreme Court of British Columbia and practiced commercial litigation in Vancouver. Since joining TRU Law, he has received the Teaching Excellence Prize from the Student Law Society 3 times, in 2013, 2014, and 2022. He also received the University-wide Faculty Excellence Award in recognition of outstanding teaching contributions. That was in 2019. And the University-wide President's Award for Excellence in Scholarship in 2018. Dr. Hunt's primary research interests concern the law of privacy, especially in the tort context. The scholarship has been cited by the Supreme Court of Canada, the Ontario Superior Court of Justice, the British Columbia Supreme Court, and in Law Reform Commission's report in Australia, New Zealand, Ontario, and the European Parliament. He received the David Watson Prize from the Queen's Faculty of Law for 2 articles judged to make the most significant contribution to legal scholarship in 2013. His work on privacy has appeared in many leading journals, including Cambridge Law Journal, Oxford University Commonwealth Law Journal, Oxford University Comparative Law Forum, McGill Law Journal, Queen's Law Journal, Alberta Law Journal, and the Supreme Court Law Review. He recently edited a book, The Last Frontier, Digital Privacy and Charter, and it was published by Thomson Reuters in 2021 with Professor Robert Diab, the respondent. He is currently working on a monograph under contract with Owen Law on privacy and search and seizure, also with Professor Robert Diab. It doesn't seem as though he feels he needs to diversify, right? Dr. Hunt's second research interest concerns the law of obligations, especially contract law, unjust enrichment, and equitable wrongdoing. The scholarship has been cited by the Supreme Court of Canada and the Quebec Court of Appeal, and has appeared in journals including the Cambridge Law Journal, Oxford University Comparative Law Journal, Intellectual Property Quarterly, UBC Law Review, Supreme Court Law Review, and the Canadian Business Law Review. Dr. Hunt also writes about the law of evidence and has published several papers in the International Journal of Evidence and Proof and the Oxford University Commonwealth Journal. He recently edited a book, Evidentiary Privileges, and his evidence on scholarship has been cited widely. Along with Professors Robert Diab and Lorne Neudorf of the University of Adelaide, Dr. Hunt is the founder and editor-in-chief of the Canadian Journal of Comparative and Contemporary Law, a thematic academic law review that publishes scholarly essays annually, concentrating on different legal topics. Dr. Hunt is a stalwart in the faculty, and he throws his weight into meaningful service. Most notably, he has chaired the Appointments Committee very successfully over the past 2 years, and have been instrumental in ensuring that TRU law draws quality researchers and teachers. He is well known in the faculty for his collegiality and his commitment to EDI initiatives. I personally enjoy his quick, clever wit and his boundless energy. Professor Hunt shares a household with 3 formidable females, Alison, Veronica, and Brittany. He's also a keen golfer and gardener, and the list goes on and on. But with this, I'm going to hand you over to our very formidable, in his own right, Professor Hunt.
Thanks, Dalian. I've got a mic. Yeah. I think I should get my water here. Okay. Well, thank you. Don't want to spill on myself here. Thank you very much, Dalian and Provost, for the warm introduction. I'd like to just jump right in. So the title of my presentation is, it's a bit of a mouthful, Normative Tensions in Constitutional Privacy Adjudication. And my comments here really flow out of a larger book project that was just mentioned by the Dean. I just completed with Robert Diab on search and seizure law. So thanks, Robert, for letting me ride your coattails once again. And I'd like to take you through 3 sort of areas here. The first, I just want to sketch for those of you that are unfamiliar with constitutional privacy, sort of how the courts go about assessing that in general terms. I then want to foreground what we might call the sort of normative tensions that underpin how we assess privacy rights. And then I want to turn to illustrate what we might call difficult cases or hard cases and see how different normative underpinnings really suggest different answers to these cases that have in fact arisen in the Supreme Court of Canada. So just to begin, to take the first part here, by way of sort of brief background, the Constitution, the title is Constitutional Privacy Adjudication, but interestingly, the Constitution doesn't actually have a right to privacy. It doesn't mention privacy anywhere in the Constitution. What we do have is a Section 8, which provides for a security against unreasonable search and seizure. And like all constitutional provisions, questions arose immediately of interpretation. What does that mean? When does one have a right to be secure against search and seizure? What is an unreasonable search and seizure? And in the very first case to address that, the Supreme Court of Canada in 1984, so 2 years after the Charter was passed, really borrowing from American jurisprudence, determined in a basic sense that the right to be free from unreasonable search and seizure begins where the individual can demonstrate a reasonable expectation of privacy in the subject matter of the search. Okay? And it's worth just pausing here to emphasize there's really a tremendously important issue here for all of us as Canadians, because this reasonable expectation of privacy concept, which I'll refer to often as a REP or an REP as well in my remarks, this operates as a mediating device, or maybe another way of saying that is a constitutional threshold. Okay, so to flesh that out a little bit. The question is a binary one. One has a rep or one doesn't. Okay, it's a binary, and if a rep exists, if you have an expectation of privacy in the subject matter of the search, then the police must justify what they've done. The search must be authorized under a reasonable law, and the search itself must be conducted in a reasonable manner. Okay, and I won't be speaking more about those other aspects of the test today. But if the answer is no, that's what I want to focus on. If the answer is no, there isn't an expectation of privacy, then the charter is simply not engaged. Okay, the police are in practice and in principle free to conduct that investigative technique with impunity. There's no judicial control. There's no warrant required. It is simply fair game. Okay, so that's why it matters. We need a rep. We need to determine whether there's a rep, and if there isn't a rep, then the police can conduct that investigative technique at their sole discretion. Okay, so that's a sort of a primer, I suppose, on Section 8. I'd like to turn to the next phase of the talk and talk about normative considerations that underpin the expectation of privacy analysis. Now, the court has developed a rather elaborate framework with multiple considerations, the details of which would not fit well into this talk. So I'm going to sort of put that aside. I can see we have some first-year law students back there who no doubt are preparing to be examined on that complexity any minute, so sorry, no tips today. But all of these factors are to be assessed normatively, the court has said. So leaving the particular factors aside, what do we mean by normatively? What is a normative assessment? And essentially we're talking here about whether there's an expectation of privacy is laden with policy considerations, okay? They're value judgments, okay? And when I say normative, that's what I mean, because that's what the Supreme Court of Canada has said for years, from the very earliest cases. To give you a flavor, there are a number of these normative principles. To give you a flavor of two that I think are uncontroversial and principled, and sort of move us into this space, let me mention two. So the first is, it's been said consistently from the earliest cases that the REP standard contemplates a normative as opposed to a descriptive standard. Okay? The idea being it's a question of ought, not a question of is. You know, ought the individual or should the individual be entitled to constitutional privacy in this particular circumstance, not in fact is privacy being respected by the police in this particular circumstance. It's not a sociological question, it's not an empirical question, it's not a descriptive standard, it's a normative one laden with policy considerations. And the reason for that makes a lot of sense. The reason for that is that if the expectation of privacy were purely an empirical matter, the right would be potentially self-eroding, because the more that privacy was invaded, the less reasonable it would be to expect it in the future. Okay? The police could unilaterally diminish privacy by just increasing their snooping and making everybody suspicious. Okay? So there's sound reasons why we say it's not descriptive or empirical, it's normative. This conjures images of 1984, right? No, if it were a descriptive standard, nobody could reasonably expect privacy anywhere because everybody knows Big Brother is always watching, right? It's that sort of idea. So I think that's unobjectionable and principled. Okay, another unobjectionable and principled normative standard is the principle of neutrality, although it might arguably, or Professor Diab and I argue in our book, might be under assault, but that's for another time. The principle of neutrality is that when we're assessing whether there's an expectation of privacy in the subject matter of the search, we are not concerned with whether the subject matter is unlawful or unethical or immoral, illegal. Okay? That is not part of the analysis. So saying that the other way, one can have an expectation of constitutional privacy in illegal subject matter. Okay? You might think that's counterintuitive. Why would we recognize a constitutional privacy interest in a fentanyl lab, let's say, okay, in the legal subject matter? Again, there are sound policy reasons for this, because really the concern is avoiding fishing expeditions by the police, right? If the police could, if it were otherwise, if the unlawfulness was a factor disentitling one to privacy, the police could in theory kick down every door on fishing expeditions, and if they happened to find something illegal, they could point to the illegality itself post hoc to justify the search, okay? If that were the case, the amount of privacy in society would be potentially zero, right? So these are normative principles, and this sort of enters us into the space. But notice the two that I've mentioned here. It's not an empirical analysis, and the principle of neutrality says you don't consider the illegality or unlawfulness. These are really negative sort of injunctions. They tell you what not to do, right? How not to assess the reasonable expectation of privacy. But we're still left with the question, well, how then positively do we assess a reasonable expectation of privacy? How do we do that? And here the court has also, I think, articulated underlying normative principles. And I think there are really two sort of frameworks, and this is really the main part of the talk here. And depending on how one answers, which of these lenses is adopted, the question might look very, very different. And I'll take you through that in the third part of the talk. So the first sort of, we'll call it paradigm, is the sort of normativity of privacy. Let's say that. And this is the controlling, dominant, most cases analysis. So what do I mean by that? Well, there's really two things in the normativity of privacy. When we ask, is there a reasonable expectation of privacy, the court is going to analyze the situation and say, well, is this conceptually private? I mean, is this private? Maybe in a dictionary sense, in a philosophical sense, in a conceptual sense, even to an extent a sociological sense. Is this the kind of thing ordinary people regard as private? Okay, these kind of questions. And we'll see that often leads them into searching for meaningful inferences. They'll say, well, what does this information tell us about the individual? Is it meaningful? Does it reveal something about their personality, about their lifestyle choices? If the answers to those questions are yes, the court will call it, biographically core information. It's meaningful, and therefore it's private, okay? Medical information or internet search histories are biographically core and uncontroversially private on that analysis. So that's one thing the court is doing. Another thing, and relatedly to this privacy paradigm, is the court is going to look at the values that underpin privacy. They're going to say, well, why do we care about privacy? And if those values are implicated, it's going to militate in favor of an affirmative answer, saying it is private. So, that's another large topic, but broadly speaking, we care about privacy for three reasons. We say it matters to individual dignity, autonomy, and personal integrity. So if the search engages with or entrenches on any of those underlying values, that's a very good indication that it is private. So we see this in the cases that involve personal privacy, like a strip search, for instance. The court doesn't even really talk about an expectation of privacy. They just say that the dignity and autonomy and personal integrity of the individuals engaged, clearly it's private. It doesn't really require analysis. Okay, so the point here is that the privacy paradigm focuses on the conceptual, whether it's conceptually private, and additionally sometimes whether the reasons we care about privacy, the underlying privacy values are engaged. And that sort of leads to the conclusion of whether there is or is not in the circumstances an expectation of privacy, okay? But there's another approach latent in the Section 8 jurisprudence, the minority cases I would suggest, but they go back a long way as well, and they continue to pop up occasionally, where rather than adopting what we might call the privacy paradigm, we could call this the sort of surveillance paradigm, or it's a normativity of the rule of law. Okay, it's another way of analyzing these problems. And this really focuses the attention, it shifts the attention away from the privacy of the individual towards the activities of the state. Okay, it's a very different focus. It's not a question of whether it's private. It's, on this view, a question of whether citizens should be free from this type of intrusion. Okay? And the normative emphasis under this we'll call this the the rule of law or the surveillance paradigm. The focus here is on democratic norms and the rule of law. Should citizens be subjected to this intrusion without a warrant? It's that kind of a question, okay? What are the long-term implications of arriving at a negative answer? If we say there's no expectation of privacy, we've already established the police have free rein to do this. They don't need to justify it. They don't need a warrant. There's no judicial control. What are the long-term implications to freedom in an open society of arriving at a negative answer? Okay? It's a very different way of analyzing the problem. And in a moment, I'll take you through some cases that I think really illustrate the way we ask the question really leads to a different answer. Okay? So in short, just to summarize, so we have these sort of two paradigms in mind as we move into some contextual examples. The privacy paradigm asks us to assess the privacy from a conceptual matter of the thing at stake while drawing also on privacy's underlying values. The surveillance paradigm asks us normatively whether citizens should be free from this form of state interference if Canada is to remain a free and open society. Okay? All right, so having sort of illustrated these two underlying sort of normative principles that influence the REP analysis, I'd like you to take you through sort of three examples of, I think, what are hard cases, and notice how the answer might look different depending on which of these concepts is deployed. Okay, so the first deals with, I'll just sort of map them for you and then we'll go through. The first deals with what we might call ostensibly anodyne information or trivial information, information that doesn't really appear all that important on its face. Okay. The second situation is where the individual lacks control over the territory that is being searched. Okay? And the third deals with circumstances of so-called abandonment, where you might have had something that was private, but you've thrown it in the garbage, let's say. Okay? All right, so let's start with the first one. So, ostensibly anodyne information or trivial information. And I'll take you through some of the leading cases and then have some commentary. So RV Tesling is a leading case that our 1Ls have no doubt studied. And here what the police did, I have to sort of take some liberties to simplify. These are rather complicated cases, but just to give the sort of essence of what's happening, which I think is still accurate. So the facts here, the police are flying an airplane over houses in a neighborhood, and they're targeting the houses with a forward-looking infrared device, which is like a heat-seeking camera, essentially. And what does that do? It reveals heat patterns within the home. It's penetrating the roof and revealing, blues and reds like you've seen on TV to determine what's hot and what's cold. It doesn't show any more than that or any less than that, okay? Why are they doing that? They're doing that to detect grow-ops, right? Patterns of heat that would be consistent with a grow-op, right? And they would then like to use that information to go get a warrant and search the house. That's the plan. But notice there's no warrant for the original flying around. It's a warrantless search. So the question is, do you have a reasonable expectation of privacy in that, of the police flying above houses and targeting you with infrared technology? And the court said, no, you don't. There is no, this is 2004, Supreme Court of Canada. No, you don't. There is no expectation of privacy in the heat patterns that are emanating from your rooftop. And when assessing this, the court, they characterize the information, this as an informational privacy claim, right? There's no physical intrusion into the property. It's the heat is information about what's happening in the home. So it's an informational privacy claim. And the court says, well, informational privacy claims turn largely, though not necessarily always, there's been a bit of a backtrack on that more recently, but at this stage it was certainly true. Informational privacy claims and whether there's an expectation of privacy in information turns very much on whether they reveal biographically core information, would be the idea. Biographically core information is information, the court says, that reveals intimate details of the appellant's life. Okay, so the question for the court is this telling us anything about the activities in the home? Who's there? What are they doing? What's going on? Or is it just meaningless? Is it just meaningless heat that's escaping from the roof? Well, because the court has framed the question very much through the privacy paradigm and called it informational privacy and said it turns on biographical core inferences, and because this does not reveal anything about the activities in the home, it's simply heat, it's not private, it's not sensitive, there's no expectation. Okay? That's what the court said. And there are plenty of cases that we could get into that are analogous. I'll give you one more very briefly. A case called RV Plant, similar but different. The police installed a recording device to measure electricity output on a house. Again, looking for a grow-up. You could tell the amount of the electricity being used, but also more importantly the cycles of usage, and they can estimate if that's consistent with a grow-up or not. They've got a way to sort of draw inferences about the presence of a grow-up through the cycles of electricity consumption, again without a warrant, right? Do you have an expectation of privacy in the data, the electricity consumption cycles and data emanating from your home is the question, and the court again says no. They say no, and they cite the last case, and they say this is meaningless. It tells us nothing about the activities in the home, the lifestyle choices. It's just patterns of electricity usage. It's anodyne. It's trivial. It does not allow for meaningful inferences about the occupants. No expectation of privacy. Okay? Now, I'm not prepared to defend those cases, but I will say at a minimum, maybe a maximum, you can at least appreciate if the controlling question is this private, that these are at least understandable, maybe not defensible, but understandable that if the question is it private, and if the information is not telling you anything about the activities in the home, many people might say it's not private, it's just innocuous information. It's certainly not implausible to say that, let's say, okay? But the problem, and I'd like to take you into some tension now, the problem is this: when you adopt the privacy lens, you search for meaning and meaningful inferences to make something private. And sometimes this leads to some very artificial distinctions that produces irreconcilable cases and causes some difficulty in the jurisprudence. And I'll give you an illustration of that. There's a pair of cases, again familiar to our 1Ls, dealing with sniffer dogs, okay, more recently. And to simplify, they're companion cases at the same time. One deals with someone in a bus station, another with a student in a school, I believe, but not a lot should turn on either of those, I don't think. The point is the police approach individuals with a sniffer dog, and the sniffer dog sits if they indicate positively the possession of drugs, okay? So, do you have an expectation, again, without a warrant, and police just doing this, do you have an expectation of privacy in that? So, we have to characterize what is the nature of the privacy interest. They say these are informational privacy cases, like the last cases, rather than heat emanating from the home or electricity consumptions, rather than that kind of information. These are, we call these odorous emanations from the bag, right? They're not going into the bag, then we'd be into personal privacy. They're not doing that. They're smelling the air around the bag. Odor, do you have an expectation of privacy in odorous emanations is the question. And here, in both cases, the court, maybe surprisingly in light of what we just said, it says yes, you do. You do have an expectation of privacy in these odorous emanations because this allows for sort of meaningful inferences. And I would just say, it's hard to really distinguish the situations. They look very similar. Whether it's heat escaping from your home or electricity consumption about the home or odorous emanations from your bag, they all seem on their face completely anodyne and innocuous and not meaningful. They're meaningful really in no sense other than one sense, that sense being they tell the police exactly what it is that they're looking for. In all three cases, they tell you you're either running a grow-up or you have drugs in your bag. They tell you that, but if having drugs in your bag is meaningful in these cases, but running a grow-up is not meaningful in the other cases, it's very difficult to sort of reconcile those, I would say. And the point, really the broader point I want to make, without picking too much on the particular cases, is that focusing on the meaningfulness of the inferences might not be the right question. I think it follows largely from a privacy analysis, but maybe the privacy analysis is not necessarily the right question when you're dealing with anodyne, trivial, ostensibly meaningless information, okay? Maybe the question is not how private is the information from a constitutional perspective in a conceptual sense, but But maybe the question is this. I mean, do you want to live in a society where the police can fly planes over your house with infrared sensors, or monitor your electricity records, or walk drug dogs up to you in public places, indiscriminately searching anybody without any articulated suspicion or without a warrant? I mean, do you want to live in that kind of a society? And if you answer no, I don't want to live in such a society, I would suggest the answer has a lot less to do with privacy than it does with your concerns about an overweening state and the implications for individual freedom in an open society. Okay? And if I'm right about that, I think the central issue in these cases might be better approached through the language of surveillance and freedom and the rule of law than through the language of privacy. Okay? And I think we have case law that sort of reflects that. An older case called R.V. Evans reflects what I think is Supreme Court of Canada 1996, reflects, I think, clearly, albeit implicitly, this paradigm of surveillance rather than of privacy in a case analogous to the ones before. So let me take you through that. Here the police approached an individual's house, and they had a ruse. They were pretending they wanted to communicate with the owner, but that wasn't true. It was found to be a ruse. What they really wanted to do is to knock to induce the person to open the door so they could get a sniff, because they suspected there was a grow-op again. A lot of grow-ops, because these are all moot now, post-legalization. But they do that. They knock on the door, he opens it, and they get a sniff, and so on. And the question is, do you have an expectation of privacy and, I guess, what we would call the odorous emanation from your house, okay? The strong smell of growing marijuana. And the Crown here leaned hard on, of course, suggesting no, there's no expectation of privacy, and said, look, this is innocuous information. It doesn't lead to any meaningful inferences about anything in the home, other than the illegality itself. So they said no expectation of privacy. And the court, two judges gave very short shrift to that, okay? Justice Sapinka and Laforet are the two. And Justice Sapinka, really didn't spend a lot of time on the REP analysis. Instead, he said, look, he focused on the implications of arriving at a negative answer, of accepting the Crown's invitation to say no REP. He said, if I arrive, I'm paraphrasing, but if I arrive at a negative answer, if I say there's no REP, this raises the Orwellian specter of uncontrolled police spot checks, particularly targeting high crime and or racialized neighborhoods. Okay? Justice Laforet, for his part, concurring, was even more direct. He said, this is a simple question. This is a simple question with a simple answer. You do have an expectation of privacy because our society simply cannot accept police wandering about sniffing our homes. Okay? And he continued and said, this is fundamentally irreconcilable with what people expect in a free and open society. Okay? So the point I'm making here, just to wrap this little section up, is that in cases involving relatively non-intrusive searches of trivial or ostensibly anodyne information, the answer to the expectation of privacy question looks very different depending on whether we are searching for privacy as a conceptual matter or whether we are concerned with freedom and unconstrained state fishing expeditions. Okay? It looks very different depending on which of those sort of lenses we put on. Okay, I'd like to take you to a different problem, the same two paradigms, but different problem. And here we're talking about control over a space, okay? And just by way of sort of background, the Supreme Court of Canada very often will, when dealing with an expectation of privacy case, they will first characterize it as one of three types. They don't always do this, and sometimes there's overlap, but in a general sense, there's sort of three privacy interests, let's say. Okay, there's personal privacy, so that's your body, so strip searches would be a very obvious example of that. There's informational privacy, which is all the cases we've just seen. Those are all, it's the information that you're claiming privacy over. And then there's territorial privacy, which is you're claiming a privacy interest in a space, in a house, let's say, okay? Now, just as a caveat, the court has made, I think, really tremendous strides in recent years with respect to informational privacy, such that now the lack of control over information is not dispositive. It's not even that important in assessing whether you have an expectation of privacy. Okay, so there's cases, maybe most dramatically, in a text message. If one person sends a text message to another, the police search the recipient's phone and find incriminating evidence by the sender. The question is, does the sender have an expectation of privacy in information found on the recipient's phone? Now, one might think, well, how could you possibly? I have no control. Once I send a text to you, I have no control over that. I can't, how can I claim an expectation of privacy over something I have no control over? But the court has rejected that, and they've said it's not dispositive. One does actually have an expectation of privacy. The sender of a text has an expectation of privacy in the phone of the recipient of that same text. Okay, so control is not particularly important anymore as of recently in the Supreme Court of Canada's jurisprudence for informational privacy. Okay, but matters are very different, one might say, out of date in light of what I just said when it comes to physical spaces, when it comes to territorial privacy. Control is very much important, remains so. So I'll give you an example. It's a case called R.V. Edwards. Police search an apartment, and they find drugs in the apartment, and they charge a man who's in the apartment with possession of drugs. Now, the problem he has is it's not his apartment, it's his girlfriend's apartment. He's at his girlfriend's apartment, he's a guest. He's a guest in her apartment, but they believe the drugs are his and they charge him. So he says, well, can I have an expectation of privacy in the space? It's a territorial claim because she would surely have an expectation of privacy in her own apartment. It wouldn't be a problem at all, but he is not her, he's a guest. Do you as a guest have an expectation of privacy in someone else's apartment? Territorial privacy. And the court said no, there's no expectation of privacy, and they focus very much on this idea of control. They say you're simply a guest. You don't have a right to control access, okay? And how can you speak meaningfully of a privacy interest in a territory if you can't expect to control any access to who enters it or not? Okay, so the lack of control is largely dispositive of his expectation of privacy. Okay, another case called Bell Navis. I'm not sure if I'm pronouncing that right. Also Supreme Court of Canada, very similar, dealing with a car. Okay, the police pull a car over, they find stolen property in the vehicle, they charge one of the passengers in the back seat with possession of stolen property. Okay, same issue arises. The accused in that case, a woman says, well, I have an expectation of privacy as a passenger in a vehicle, surely. And the court says, no, following the last case, you don't. If a guest in his girlfriend's apartment doesn't have an expectation of privacy, then surely a passenger in the vehicle doesn't either, right? Driver does, you don't, you're a passenger. Again, very much on this idea because you're simply a guest without the right in law or the practical ability in fact to regulate access to the car or the house. And without that, you lack all meaningful control, and without that, you have no expectation of privacy. Okay, and again, as a purely conceptual matter, from a privacy paradigm perspective, it's not an entirely unprincipled thing to say. It does, control is something that's been argued in the academic literature for 50 years. There are plenty of people who think it is difficult as a conceptual matter to claim a privacy in a territory that you can't control in law or in fact. So it's not necessarily wrong, but there's another way of looking at these things, okay? There's another way, and Justice Laforêt, who we just encountered a moment ago, dissented in both cases, so this is not the law. He was a dissenting judge, but he would have said, yes, there's an expectation of privacy in both of these cases. And I'll just take you to his comments in the second one, the Carr case. He focused very much, I think, again, implicitly but clearly, on the what we call the rule of law or the surveillance paradigm, not the privacy paradigm. For him, the matter was straightforward. He said that focusing on the policy implications of the majority's approach of saying that there's no privacy, he said this would virtually eviscerate the right of privacy of all passengers, or at least a wide range of passengers in any automobile, to be left alone by the police. That's what the majority are doing here. And he says, again, he's quite pithy in his dissent here. He says, I find that approach wholly inappropriate in a free society and quite simply disturbing in its general implications. Okay, the idea that there is no privacy for passengers in a vehicle. Interestingly, this was the state of affairs until 2020 with these territorial privacy claims. This came to the Supreme Court of Canada again in a case called R.V. Lee, but unfortunately the court decided on another ground. So they made some comments that might suggest revisitation, but the case was decided on another basis. So here, just to give you an example of the facts, and it really is a manifestation of the concerns Justice Sapinka had a few cases ago about unregulated police targeting of high crime and racialized neighborhoods. Recall that was one of the concerns he had about getting a sniff of someone's home. He thought that raised an Orwellian specter. Well, I'd suggest that's exactly what happened in R.V. Lee. Okay, so we're in Toronto. I believe it's in Toronto, but it's a big city in any event. I don't have that in mind. Police are wandering around a sort of housing project, and there's a group of black men having a barbecue in a private courtyard. Okay. And the police just help themselves and walk in, and they find one man there who has possession of, I think it was drugs, it might have been a gun. Was it drugs? Colton would know off the top of his head. Maybe drugs and a gun, both, okay. Neither here nor there. He's breaking the law and he's arrested. And he then says, well, I have an expectation of privacy. But notice the problem, it's not his, he's a guest in the backyard of a housing project that he doesn't live in, okay? So it would appear to be controlled by the cases we just established. And indeed, the Ontario Court of Appeal majority said just that. In fact, they were explicit. They said, quote, one cannot speak meaningfully about a right to privacy in territory if you cannot control access to it in law or fact. Okay, so the answer is no, sorry. But he appealed, he went to the Supreme Court of Canada. Now, ultimately, the case was decided on other grounds, so we don't have a complete revisitation of that proposition, but there was some discussion by some of the judges that maybe in some circumstances, quote, an accused could have an expectation of privacy as a guest on another's property. Okay, so they've contemplated that this might be revisited. And I would just suggest that if and when that is revisited, it might be more meaningfully and usefully, productively revisited through the lens of the rule of law than through the lens of privacy. I'm sure that will come eventually. Okay, the very last area I'd like to take you to that is also, I think, quite concerning in its overall implications, from my perspective anyway, deals with this idea of abandonment, okay? So I'd like to introduce that for you. So I'll take you to a case, R.V. Patrick, 2009, Supreme Court of Canada. And we have the police here, to simplify, rummaging through the garbage of an individual that he put out in his back alleyway for collection. Okay, and I think there's suspicion that he was running an ecstasy lab or something. So they're looking for chemicals that would be consistent in that to then apply for a warrant, something like that. But at a higher level of abstraction, the question is do you have an expectation of privacy in your garbage in the alley? Okay, that's the question. Answer said, the court said no. Although they started the analysis noting, look, this is actually informational privacy because they want the information that's in the garbage bags. And we could quarrel with whether that's accurate, but it's neither here nor there for this point I'm making. And they say this is actually very private stuff, potentially, right? I mean, your household garbage could have medication in it. They could draw meaningful inferences about the kind of medication you're on. This is biographically core. This is private stuff, potentially. So it's not really problematic from that perspective. It should attract an REP, but they say, but there's a supervening principle of abandonment. He's thrown it out. It's garbage. He's gotten rid of it. And again, so there's no expectation of privacy. Abandonment becomes a sort of supervening consideration that will, we might say, override even what would otherwise be private information. So it's very powerful. And again, I don't want to defend it, but it's not entirely off base. One could see from a conceptual perspective, if privacy as a conceptual matter is what we're looking for, it might not be easy to say that one has a continuing privacy interest in that which they've thrown away. It's not an entirely unreasonable thing to say. That's essentially what the court says. Okay, the problems with that, though, I think, is that type of analysis becomes a lot harder to justify if we start analyzing this through the lens of the rule of law, as I've called it, rather than the lens of privacy. It might be defensible from privacy, but maybe less so from the perspective of the rule of law. And let me take you into how this has developed. This idea of abandonment, I think, really highlights the concerns has become a very powerful principle that essentially trumps a constitutional privacy interest. And we see it particularly, well, we see it all over the place, but most concerning for me personally deals with situations of police collecting discarded personal items to test for DNA, okay? I think we'd all agree DNA is something that's rather private, supports a lot of meaningful inferences into one's lifestyle, but if it's abandoned, then there is no expectation of privacy on the theory of the last case. The leading case there is, well, I'll give you a typical example, is the police will surveil an individual and follow them around until they throw a cigarette butt out or a Kleenex or whatever, and then they'll collect it and test it and get the DNA. Okay, so in that typical scenario, there's no expectation of privacy because it's been abandoned. Now, the leading case there is a case called Stillman from the Supreme Court of Canada, and they said that. They said this is unobjectionable from a constitutional perspective because of the principle of abandonment, okay? Now, there is some caveats. If you're in police custody, it's different, and that for reasons I won't get into, but if you're wandering around the street, if you're not in police custody, and you discard an item, it's considered abandoned, and the police have free rein to test that for DNA. Now, whatever the sort of merits I would suggest of that from a privacy perspective, from a conceptual privacy lens, I think it does look rather different from a rule of law perspective, right? If, as we've seen, the privacy analysis is laden with value judgments concerning the long-term consequences of government action for the protection of privacy, then, I mean, is it not concerning that the police can rummage through your garbage or test discarded items for DNA at their sole discretion without a warrant? And once again, I would suggest that the answer to that is that it is concerning. I'm not entirely comfortable with that in a free and open society. I think the reason for that has very much more to do with concerns about surveillance and the rule of law and freedom than it does about the language of privacy. And I think foregrounding that analysis would probably do all of us well in the future. Okay, so thank you everybody. I'm very, very happy to have had an opportunity to share my research, and thank you again for the kind introduction. All right.
All right, so as is our way, is to invite a colleague up to speak in response to the presentation and the scholarship and the scholar. So I'd like to invite Dr. Robert Diab to speak to us now. Thank you.
Thank you, everyone. Professor Hunt is a hard act to follow, but that was great. I really appreciated it. I'll just share a couple of thoughts. I'll try and be brief. So I'm a criminal law scholar, and one of the benefits of working closely with another scholar who isn't in your area, but you're working on the same thing, is that you gain a completely different perspective. And so in my case, I'd spent a bit of time looking at all these cases from the perspective of a criminal lawyer, and a kind of a narrow focus relative to Professor Hunt's, who approached the issue from privacy theory. So he had spent a number of years reading older literature about, the abstract concept of privacy theory. And so he, as you could see, listening to the lecture, he was reading the cases at a fairly deep level. He was sensitive to the way that they were thinking about privacy at a very sort of, maybe subconscious level. Maybe that's not quite the word, but I hope you have my point. One of the things I've learned working with Professor Hunt is that the deeper you drill down into the concept of privacy, the less clear it is, the harder it is to make sense of it, really. It begins to fall apart. And so he's bringing that picture to us. The difficulty of maintaining the coherence of the concept, the clearer you attempt to be about what it means exactly, what is privacy. So with that in view, I was fascinated by the way that he could trace those two readings of a reasonable expectation of privacy in the court's jurisprudence. And I'm persuaded that he's right, that there are these two strains. On the one hand, they define it in terms of privacy. Is what the police discover when they carry out a search, is it something secret? Is it something, the public or somebody exterior to me would not know? Does it unveil some secret information? There is that one thread in the jurisprudence. On the other hand, there is, I'm persuaded, another thread where they seem to talk more about what the public would be offended, what the citizen would be offended to see the police be permitted to do, that sort of thing. But from my sort of heightened sensitivity to the underlying privacy theory that I've learned from Professor Hunt, one response to the argument we heard today would be that, so just to remind you, if I understand Professor Hunt correctly, the core argument here is that there are two ways to arrive at, to decide the question, is there an REP? One way is to ask the privacy question. The other one is to ask the, as he put it, surveillance law enforcement question. Do we want police doing this sort of thing? Knocking on people's door to smell odors coming out of, emanating from the home and so forth. So he's given us those two versions and has suggested to us that he thinks the court is on sort of firmer ground when it uses the latter paradigm. My response is to say, if that's the case, if they do use the latter paradigm, are they really escaping privacy theory? In other words, if you were to ask, well, what does it mean then for us to be offended by too much surveillance power or heavy-handed conduct on the police? I would think that the further we interrogate our reasons for being offended by that kind of conduct, the more it would start to sound like privacy, the concept of privacy and privacy ideas. Maybe one other response to make to Professor Hunt's comments today is to agree with him that much turns, when they're assessing the REP question, on the debate about the normative questions. So in other words, whether there's an REP in something very much depends on how you frame your understanding of what police are doing. So to give you an example, a minute ago, he made the point that, in the case of houses and heat emanating or electricity patterns traceable by things the police do, the court concluded there was no real meaningful information to be gleaned, certainly none that you could call private. But on the other hand, they decided that the odors emanating from a bag were private, and it didn't, it's an apparent contradiction. One other possibility, though, is to say it's really a contest over how do you formulate the question. So on one view, if the question is, what's the difference between, smells emanating from your bag or heat signals, then maybe that you can't reconcile those three decisions. But if the question is something like, do I learn something significant about you if I smell, odors of like gym clothes emanating from your bag? The answer is yes. Whereas it may be different, in another case. So I think we could get around some of these concerns by saying that what's really going on is we're arguing over the nature of the question. But aside from that, I want to thank Professor Hunt again for a wonderful lecture, and congratulations on your promotion.
Close us out, as they say. Thank you. Great. Lots of ideas. So thank you for listening, and please enjoy food and conversation. I'm sure Dr. Hunt and Dr. Diab would love to have a scintillating conversation about some of these questions. So thank you very much again for coming, and enjoy